Petitioner is praying urgent listing and hearing can 1 of 2025, can 2 of 2025, MAD number 932 of 2020.
As soon as the file arrives here, we will put it in the list. You don't have to repeatedly mention. We have taken note of that. Please keep a watch on the list. Once the list matter comes, we shall include. ওটা একটু দেখে আনিয়ে নাও।
Number 1, my lord, I am for the appellant. Online. Online. Well, reply has not ready, my lord.
Your reply is not
Not
ready.
ready because they have filed this on 17th July, my lord.
So when will you give the reply?
1 week time is necessary, my lord.
No, 2 weeks. Yes, will appear after 2 weeks. Use your reply in the meantime.
On, my lord, fix the date, my lord.
After 2 weeks, it will come.
After, my lord, fix the date, my lord.
So, Baba, that is what I am saying. After 2 weeks, it will come.
My lord.
আচ্ছা, কত
But I appear on behalf of the respondent number 1 to 4 and 8 to 12.
it will appear on 6th August. You complete your reply.
Grateful.
Grateful.
Yes. দেখে যাও।
I appear on behalf of the appellant, my lord. Lordship might recall, my lord, in this matter, the bank appeared, the appeal preferred by a third party, my lord, the company, challenging the order of the trial judge. Now, my lord, challenge was, my lord, a notice.
Who is your other side, sir?
My other side, my lord, on the last day appeared, and in their presence, my lord.
Lordship, I appear on behalf of the private respondents, the
Lord.
siblings, Lordship.
And virtually.
Oh, virtual.
Lordship, Lordship, kindly allow me to make submission virtually. Lordship, may I pray before your Lordship? Because, Lordship, today there is...
Yes.
Lordship, am I audible, your Lordship?
Yes.
Lordship, otherwise I am ready with the matter, but today I am little handicapped because of the issue all over in the city and because of the less of manpower, your Lordship. Any day, tomorrow, day after tomorrow, any day, your Lordship.
Only thing, my lord, the interim order, which was in the form of an undertaking, that is still today. And I apprehend because of the past conduct of the bank, because on the day when I preferred the
Lordship, all these are allegations, your Lordship, since I have given an undertaking and since I am seeking accommodation, I will continue with my undertaking.
let that be extended, my lord, the undertaking.
He says he'll continue with that undertaking.
Kindly, my lord,
Let us see,
sir,
but
kindly
we
see the
have
order.
recorded that. Is it not it is not time barred? We
But
have
only if something could be recorded, my lord, that is the only thing we are praying.
July, my lord, the orders.
But I was appearing in the first appeal for the appellant.
Lord, a second, Lord.
No,
Mr. Singh,
Lordship,
your contempt application has been filed.
contempt regarding?
no, there is no contempt application, my lord.
There is no contempt, your Lordship.
No, what you are apprehending?
Kindly sees the order, my lord, last sentence. My lord, after we
Order dated?
order dated 9 July, after we preferred the appeal, my lord, they took possession, my lord. And the undertaking was that they would not part with the possession, sell.
Any third party interest?
Yes,
for-
absolutely.
No, the third party interest has already been created in view of the issuance of sale certificate. Only handing over a physical possession to the auction purchaser left, which I have undertaken till adjudication of the appeal, subject to a Lordship's kind consideration, I will stake my hand.
Lord, I was appearing in MAT 1019.
In my appeal, which is a third party appeal, Lordship did not pass any order. Lordships did not admit the six item.
Lord,
was
in
an
1019, my lord passed the order, my lord, in MAT 1019.
item, Lord, the orders passed.
Item number 6.
4 and 6. 4, my lord, appeal filed by the company, the borrower, and 6 filed by the guarantor. Lordships passed the order in the item number 6, and 4 did not pass any formal order. did not admit and no order was passed. Kindly seize the order passed on that.
My lord, MAT 1019, my lord, passed an order on 9th of July. That was, my lord, the writ petition as appeal.
Ashok, on the joint prayer of the parties, the matter, the matter stands adjourned. The undertaking given by Mr. Singh, learned advocate appearing for the respondent bank, shall continue till the next date of hearing. Stop, list the matter for further consideration on 7th August.
7th August.
Mr. Singh.
Supplement.
Lordship, am I audible?
We have kept it on 7th and we have extended the undertaking which you gave till 7th.
Lordship, instead of extension, Lordship, kindly record my submission because any judicial order will be interpreted by the adversary that the court has passed an order on merits. Kindly record my submission.
Yes.
Instead of extending your Lordship, kindly record my submission. I have made a submission before the court. I will wait till the next date of hearing instead of extension because it will it will hamper the interest of the bank and take an advantage by the adversary, which your Lordship on the last occasion has duly appreciated.
Then you have suppressed an order, did not
On the
produce before the
joint prayer of the parties, the matter stands adjourned. Please the matter for further consideration on 7th August. Stop, Mr. Singh, learned advocate appearing for the bank submits that he shall, Mr. Singh, learned advocate appearing for the bank submits that he will ensure that the bank does not part with possession of the
Lordship, possession only handing over subject. I tender apologize for interruption. Only handing over a physical position. I will not part it with position. Yes, only. Third party interest created.
That is what has been recorded by the court.
Yes. Only this my predicament, your Lordship. That is why.
That is what we are saying, Mr. Singh, that you will not part with the possession.
Oblige, your Lordship. Oblige.
Of hearing.
It is my predicament. Obliged.
Is that you will ensure that the bank does not part
the concerned premises till the next date of hearing. All right.
Lord, we have prepared a supplementary affidavit. Lord, we shall serve it on Mr. Singh, Lord, today itself through email. So that, Lord, if my Lord allows us to file that, Lord.
Come over tomorrow and give a copy to him. Why?
We'll give it to him. We'll give it to him tomorrow. My Lord may take it on record, my Lord, today.
In item 6, my lord, I beg to represent the state lordship.
Item 4, my lord.
Wait, one at a time.
Gotcha.
এটা item 6 এ order হলো। সবার নাম দিয়েছো? ওই ওনার নাম দিয়ে দাও যে stated হয়ে আসছে। Are you in item 6?
I mean, lordship, both the matters, lordship.
You are for the private response
Yes, lordship.
in both matters.
Yes, lordship.
Mr. Galib for both.
Only in 6 for the state.
Not in 4.
Lordship.
Who is appearing in 4 for the state?
Lordship.
Yes.
এটা 6 নম্বরটাতে অর্ডারটা হবে আর 4 নম্বর ম্যাটারটা এটার সাথেই 7 তারিখ রেখে দেবে ঠিক আছে
My Lord.
that is
My Lord may take the supplementary affidavit on record, my Lord.
Lord, item 4, first matter, my lord. May I, my lord, file a supplementary?
we have not passed any order in that. Keep it with you.
Very
You shall take
very
it
well.
on the next.
Very well.
My Lord.
Oblige, your Lordship.
But I'm grateful to Lordship. I shall serve him the supplementary affidavit tomorrow.
With your Lordship. Oblige.
In the copy on the next date of hearing, we will take it on record.
My Lord. We'll serve him.
Lordship.
Grateful to Lordship.
Oblige, your Lordship.
Item number 5. My lord, I take appear on behalf of the appellants.
Lord, in this matter, I appear for the private respondents.
My lord, I am challenging an order passed by the Honorable Single Judge, my lord, on 23rd of June 2025, directing the wetland authorities to remove the purported unauthorized construction and to restore the water body. My lord, these directions were issued, my lord, on the basis of a report prepared by the
You have
Wetlands
not,
Authority.
there are some defects.
My
You
lord,
have not
probably
filed
with
your
regard to
wakalatnama.
filing of the wakalatnama, wakalatnama was filed before the, my lord, Honorable Single Judge.
এটা দেখাও নাকি
কোথায়?
correct the defect will appear day after tomorrow.
My lord, the difficulty is, my lord, this is the wakalatnama and this has also been incorporated in the, my lord, CIS system. That the
Which one? You have already filed.
filed
Then
in-
why the report? See the report.
it has already been filed, my lord.
Check once.
It also appears from the CIS system, my lord. It has been duly reflects from the system, my lord.
Please check it up with the register. We take it up day after tomorrow.
My lord, the difficulty is, my lord, tomorrow is the returnable date
Of
the, my lord, before the Honorable Single Judge. And there is a direction to, my lord, submit an action taken report.
দেখি দাও When did you file the wakalatnama?
My lord, the wakalatnama was filed, my lord, on 17th of January 2025.
That's before the single judge.
Yes, my lord, this is a continuous proceeding, my lord. I do not require to, my lord, subject to correction by your lordships, a separate wakalatnama for the purpose of, my lord, filing the memorandum of appeal.
All right, show us the order.
Yes,
Who is for the state?
my lord, before the, my lord, Honorable Single Judge, Mr. Amol Sen, my lord, appeared on behalf of the state respondents.
You are for the private respondents.
Private respondent.
Which order are you assailing?
Yes, my lord, lordship may kindly take up the order. If your lordship is looking at the stay application, it is at page 130.
130.
130 of the application for stay.
Has any steps been taken by the state authorities?
My lord, my instruction is not yet.
Unlikely by tomorrow it will be taken.
But I am apprehensive, my lord, because, my lord, this, my lord, what I am trying to, my lord, canvas before your lordship, my lord, basically 3-4 points. First, my lord, this is, my lord, at the interlocutory stage, my lord, an order has been passed, my lord, granting final reliefs to the writ petitioners. If your lordships kindly take the trouble to, my lord, compare it with page 36 of the stay application, my lord, these are the, my lord,
Who is this EKWMA?
my lord, the East Kolkata Wetland Management Authority.
Who is representing them?
My lord, Mr. Sen was representing all of them, the state respondents as well as the wetland authorities.
Authorized construction detected হয়ে গেছে।
It appears that where is this report of 23rd
Yeah.
June?
The report your lordship will find, my lord, starts from page 88.
So what is the problem? They have taken steps.
Not yet, my lord. My lord, I am, my lord, assailing this order, my lord. My lord, on
And
basis-
Mr. Sen's presence has to be there, na? Suppose we pass an interim order in your favor, and you people have adopted resolution
I know,
that
my lord.
don't pass any order in the absence of the council. How we are to help you, tell us? Mr. Sen has come, is he in court? Have you seen him?
I do not know, my lord. At least not
He
in
is
body level.
to be mentioned tomorrow, first in the list.
He has come to court. He is standing on his legs in another court. Mr. Singh.
All right, then pass over.
Thank you.
Spot inspection has been conducted. Thereafter, they filed a report.
Report filed before the
Honorable
single
Single
judge.
Judge, on the basis of that report, unauthorized constructions were detected in the wetland. And pursuant to the report, after perusal of that report, the impugned order has been passed.
Hmm.
The entire construction was found to be unauthorized. Entirety.
Because as per provision of section
On the
9 of
wetlands, it cannot be done.
no construction can be done on the wetlands.
My lord, these particular Moja has been classified as urban rural settlement. There are three categories of land, my lord. My lord, provided.
Very well, we'll take it up in presence of Mr. Singh.
I shall come.
My lord, in this matter, I am appearing for the petitioner, my lord. I am praying for 1 week's accommodation, my lord.
Right.
My lord, in this matter, we have sat with for conference with Learned Council. We need to sit once more, my lord. So 1 week accommodation kindly give, my lord.
For compromise.
Conference, my lord, we have to sit with Learned Senior Council, my lord. We have sat for
2 weeks. Yes, next.
Item number 8. Item number 8, my lord.
Item number 8, I appear for the private response.
Who is for the appellate?
Anjana Banerjee, Mr. Soptang Subhasu is leading them.
Come on next Monday.
You did not come for item 4 and 6, Mr. Watson?
Well, I went to mention a matter. Popal. Not everything is
Yes.
pre-written.
Next Monday. Next Monday ki combined list. Next Monday देखो.
Item number 27.
लिखे जाओ.
28. 29. 30. 31. 32.
Your Lordship, Mr. Arun Kumar Maiti is appearing in item number 31. Your Lordship, and one just short passover, he'll just come. We have the report. He will just come and present the report to your Lordship.
Who is your other side?
Other side, they are not here.
Come tomorrow then.
All right.
Yes, my lord. I'm appearing in person. Last occasion there was direction, evidence service, and also inform the my lord, me permitted some submission I will do.
Who is your other side?
My lord, other side, last occasion they appeared and one party did not appear. That's why Honorable Court directed me for service. And also
Oh,
I
it
have,
is the Diwar garage.
yes, my lord, we are garage, service done, evidently service also.
My lord, I appear for Deva's garage, my lord.
Yes.
Yes, I appear for Deva's garage. I've received copy, my lord.
Where are you, sir?
My lord, I apologize for joining online, my lord. I couldn't come to the court because of the Mitchell, my lord. I apologize, my lord.
You have got the money for the card.
Yes,
Bank,
my lord. I have received the money for the car. Yes, my lord.
why you are not giving it now?
Yes. The dispute, my lord, before the consumer forum is, my lord, regarding this delivery of the car. We have the writ petitioner is asking the car was asking the car from us without registration, and it has been our contention before the writ petitioner throughout and before the consumer forum also that without registration of the car, the same cannot be handed over to anybody as per the motor vehicle rules. For the registration, my lord, before the consumer forum, we have placed categoric emails issued to the writ petitioner asking him about the particular registry where he wants to come and do the registry, and whether he would want to go for a fancy number mechanism or would he want to go for an ordinary mechanism. But the writ petitioner, my lord, has refused to respond to those emails. Despite this, my lord, since the writ petitioner was an advocate and when the matter came to us, we advised the client to offer refund of the money or the car with registry. Now, to that email also, there was no response.
You
After this, what?
intimated him that either take
Yes,
or the money.
yes, in 2020, in 20, before the consumer forum complaint was filed, no response, we received no response to that, my lord. And after that, what happens? The writ petitioner goes and files criminal complaints against my clients. Several of my employees leave because of this, and I have been dragged for litigation for almost 4.5 years, my lord, because of the conduct of the writ petitioner. We have shown our bona fide throughout, my lord.
Where is the car now? It has been sold.
The car is the car is in the warehouse, my lord. I have submitted the registry papers to the RTO. So now I cannot deal with the car in any manner. The car is in my warehouse.
From 5 years, it is lying in the warehouse. What remains of the car?
My lord, it is our obligation, my lord, to give the car in a running condition, in a proper condition. That is our obligation. We will do that if he chooses to take the car, we will do the registry and we give him the car in running condition. That is our obligation.
Are you agreeable, Mr. Agarwal, to hand over him the money which he has paid?
As of date, my lord, we cannot do that, my lord.
Why you cannot do that?
My lord, the reason the car has depreciated, the value of the car is depreciated, my lord, for the fault of the writ petitioner, not my fault.
Cuts both ways, na? It cut both
My lord.
ways. You are also in trouble, he is also in trouble.
My lord.
Apply your mind and talk with your client whether you are agreeable to refund the amount which he has paid. First, don't react first into this.
Yes, my lord.
You will take that instruction, and now we will go to him and ask that whether he withdraw everything if he gets the money or not.
My lord.
Yes.
My lord.
I'll take instructions on that, my lord.
Before you take any such action, we are asking you that
Yes,
the
my
problem
lord.
has to be solved. The problem has to be solved.
Yes, my lord.
You have neither got the card nor the money.
Yes, my lord.
So if you get the money today, what is your problem then?
No, there is no problem if I will get all the money along with interest. Then definitely the problem will be solved.
Right? এটা তো এখন স্ট্যান্ডার্ড প্রসিডিওর যে তোমার রেজিস্ট্রেশন নিয়ে গাড়ি দিতে হবে তখন তোমার টাকাটা অফার করে তুমি তখন নেবে that type of 4 years litigating.
My lord, can you give me just 1 minute? I submit.
What are we giving you? What do you mean, can you give me just 1 minute?
My lord, in the year of 2020, for the safe and safety, I want to purchase a car, but they did not.
Mr. Haldar,
yes, my lord.
They gave you an option that you either take the car upon registration, without registration. Hear us. Now you give us 1 minute. Without registration, the car cannot come out of the showroom. They will
No,
be in
no, my lord, the
Number
TC
one.
number, the car will be delivered. If I will run on the road, then definitely I will face consequences.
Yeah.
I will face consequences if I will run the car on the road.
Understand.
But I refund the money. Several intimation I have given them, but they did not listen my word. All the documents
May-
I have. Then
May
there
I
are
request one thing, my lord?
all the complaint before the consumer forum. I have all the papers, my lord. I am showing before your lordship. I'm not in, I have no intention to
How
lodge
much ac-
unnecessary complaint or
How much according to you is the due to you? How much according to you is the due?
my lord, 5 years, 60 EMI and 28 EMI already deducted from my account, where I did not get the car.
Very good.
And if, my lord, I have no money, I approach to the bank for purchasing a car. Bank is the real owner of the car.
Don't repeat. We are asking you according to your calculation with the interest. How much money you are entitled?
My lord, I did not calculate.
Please calculate and let us know. Please calculate and let us know. Your entire concern is that. Now, if you want to proceed, go on with the litigation, there is no problem.
Yes, my lord.
We shall consider.
My lord.
And if you are not agreeable to a settlement to that effect,
No, why not settlement? I want to settle
that is
the
why.
matter, and this should already complete.
Very good. You
Will
tell
be-
us as per your calculation.
Yes.
Then we will ask Mr. Agarwal whether you can at all claim that amount or not. We will consider. If you are agreeable to a settlement,
Yes.
you let us know that as per my calculation, this is the amount due and payable to me.
Yes, my lord.
Suppose the amount due and payable to you, according to you, it is 20 rupees.
Yes, my lord. I understand.
We'll place this to Mr. Agarwal. Now we will hear his response to that. If it can be settled, because he is also suffering problems.
Yes, my lord.
Because of your criminal complaints, his employees and everything, he has also suffered problems. Now, after the amount is specified, if he says that I cannot do so, we shall hear you and his.
Yes, my lord.
And if he says that, all right, we consider in the facts that I will not pay 20 rupees, but I will give 15 rupees. Then we will try to settle the amount.
Yes, my lord.
Years of
It is possible.
litigation from 2020 going on, sir. The mindless litigation is going on.
My lord.
Either you are agreeable or not. You come and tell us as per your calculation what is the amount. Go
Yes,
home,
my lord.
calculate what was the total loan sanction, how much EMI you have paid, and what is the due against which you will be. Thank you.
Also needs.
When can you come with this? When can you come with the calculation?
Actually, that calculation will be complete if the bank will be give some calculation, because what amount they will get from me. Because the EMI.
We have asked the bank. We have asked you. You make up your mind.
What
How
is
much
the
amount they
what
will
is
get,
the
banker?
Mr. Haldar? What is the EMI amount?
6062 EMI.
6062 into 60.
No, my lord, there are other charges have applied, and much more that amount. Because after 20 EMI deducted, rest of the EMI already
Very good.
bound.
Very good. You make up your mind and come and tell us. We first want to hear from you.
Okay, my lord. I will do exactly.
Yes.
Maybe
Next Tuesday. Come next Tuesday. You also be present along with whatever records you have.
My lord, I will, my lord. I'll place the orders passed by the consumer forum and I'll place the emails which I have issued to the complainant.
তাহলে affidavit file করতে হবে। Mr. Agarwal,
All written communications.
all those
Yes.
correspondence that you say you've had with him,
Yes, my
asking
lord.
either take back the money or take the car,
My lord.
are they on record before us?
My lord, they are not on record before your lordships, my lord. It is on record before the consumer forum, my lord. The issue there was,
Go forum and check the records.
my lord.
Are they on
My
record?
lord, I apologize. We were never given the chance to file an affidavit, my lord. I'll prepare a compilation for the convenience of the bench, my lord.
Question, are they on record before us?
No, my lord, they are not on record before your lordships.
So you do one thing,
My lord.
you use an opposition to his application. To the stay application you have obtained,
I have obtained a stay application, my lord.
stay application you give an opposition enclosing whatever documents you have.
My lord, I will do that, my lord.
We'll give a reply to it and then we will decide.
Yes, very grateful to your lordships.
In the commission, you have not given anything.
Yes, before the consumer forum, my lord, we have filed everything.
You filed.
Before the consumer forum, but before this honorable court, we were never given the chance to file an affidavit, my lord.
But they have said.
Actually, the last order I have annexed.
No.
Now, all the petition and annexer did not annex. Because this case was another. Because violation of judicial impartiality, this is the problem.
Price for patience. Yeah, well,
The present appeal has been preferred. Challenging an order dated 15 January 2025. That in the writ petition being WPA number 26983 of 2024. Heard Mr. Haldar, the appellant appearing in person. Mr. Agarwal, learned advocate, appearing on behalf of the respondent numbers 3 to 6.
My lord, I'm appearing only for the managing director. The other employees have already left Deva's garage, so I'm not representing them.
Oh, I see. You are for the managing director.
Managing director, only the managing director.
Agarwal, learned advocate, enters appearance on behalf of the respondent number 3 and prays for leave to file an affidavit in opposition to the stay application. Stop. Such prayer is considered and allowed. Stop. Let such affidavit in opposition be filed within.
2 weeks. My lord, may I make one submission, small submission, my lord? The
Yes.
stay application has been disposed of already, my lord. If it commends to your lordships, may I file a supplementary affidavit?
The application disposed of.
Yes, the Honorable Chief Justice, my lord, while disposing of recorded, there's no question for grant of any interim order. And it admitted the appeal directing paper books. That in paper book has.
What is the order? That is what is the order date?
Yes, my lord. Yes, I'll just indicate that to your lordship.
file হয়ে গেছিল।
So paper book has been filed.
Yes, my lord, paper book has been filed, my lord. I have been served with a copy of the paper book.
Oh.
So if it commends to your lordships, may I file a supplementary affidavit?
No, not required. Whatever is there in the paper book, your documents are there.
No, I was never given a chance to file an objection either before the writ court or before the appeal court, my lord. On the very first day, the Honorable Chief Justice felt that there's no scope for grant of interim order, my lord.
The paper book is present. So you appeared before the other bench.
I did, my lord. I appeared before that other bench.
Why did
the stay application was disposed of on the very first day? So I was never directed to file any objection, my lord.
So Agarwal, the stay application has not been formally disposed of as such.
My lord. We'll file an objection. We have no problem, my lord. I'm just indicating that.
Dispose of কথাটা লিখতে হবে।
My lord, I am appearing for the Union of India.
Now the documents in the, do you, Mr. Agarwal, whatever, you have got the paper book.
And the paper book, your lordship.
So from the paper book, no, whatever documents you will rely upon, that is not there in the paper book.
It is not there, my lord. None of the papers with regard to the consumer forum case are before your lordships. Even the transfer application on which the order was passed, that is also not before your lordships.
Just one.
My lord.
Where your documents annexed to the, before the district commission?
Yes, my lord. Before the district commission, everything was there.
Where is that? Why didn't you get, that ought to have been included in the paper book?
My lord, the paper book was prepared by the appellant, my lord. The appellant has prepared the paper book, my lord.
You have not annexed the district commission, what?
No, my lord, because I came to the court for challenging the transfer application. And transfer application, my transfer application rejected. That's why I came to the court.
When the transfer application is not before your lordships.
To the national was sent to the high court second bench rejected, then thereafter the division bench. This is the matter. And transfer application, it is my fundamental right under section 48 of Consumer Protection Act. My lord,
You are. No. Then you come with the records before us. Whatever document you have, as paper books have already been filed, if we consider it necessary, then we will direct him to file a supplementary.
May I file it by way of a convenience compilation for the convenience of the bench, my lord?
You prepare a compilation and come back to us. Let us see what can.
Very grateful to your lordships.
My lord, I am appearing for the Union of India in this matter.
Let it appear on 29th, be present on 29th.
My lord, my lord, I am appearing for the Union of India, my lord.
If you are not passing any order on 29th, you come. Keep that with you. File it on 29th.
Mr. Haldar, why
Yes,
don't
my lord. Yes.
you put that other set of documents in your supplementary affidavit? You are yes, that is not there in the supplementary affidavit that you are filing.
not supplementary, this is a service only. Was directed, your lordship.
No, in this district forum, they have filed an opposition.
Yes, my lord.
So district forum complaint you have given in the paper book, must have given.
No, even that is not there before your lordships.
Case will continue without my side heard, the case disposed of during the pendency of the transfer application. But it is illegal and perverse order and vitiated order, I think. So I have challenged this court because as per section 48 Consumer Protection Act.
When the district commission application you filed.
Yes, my lord.
And you sought for transfer.
No, case was continued. Then thereafter something happened.
Listen. When the district commission matter was pending,
yes,
you sought for a transfer.
Yes, my lord.
That prayer was not allowed.
Yes.
So it was, you went to Supreme Court, National Commission.
National Commission.
Now National Commission not passed what order?
National Commission, my lord, what was annexed?
Tell us now.
Yes, my lord. They said they have no statute to interfere the matter. So you will go to the High Court.
Go back to the district commission.
No, High Court. If any remedy will get from High Court, then you maybe file High Court. So as per the direction of the NCDRC, I have filed single bench. And single bench pending the writ petition, the district commission dispose of without hurt my side. This is perverse and vitiated order. And thereafter, this order I have challenged before your lordship.
So, in the meantime, in the district commission matter, the Diwar Garage must have filed an opposition.
Yes, my lord, they have filed opposition,
They have
everything
copies
under
of the
district
same.
commission.
Do you have copies of the same?
I received that,
আচ্ছা ঠিক আছে ওই 27 তারিখ রাখ ইয়েস কল দি নেক্সট
27 তারিখ
27 বললো তো হ্যাঁ 29
Yes, my lord.
yes pass over matter Mr. Sen is here এই তো মনে তুমি বলছো না বুঝতে পারছি yes
So, your lordships, my lord, I believe, my lord,
representing all the private respondents.
yes. Your lordships, my lord, I believe, have, my lord, perused the order, my lord, which is under challenge. Lordship may kindly.
You are appearing for 11-12 and other respondents Mr. Sen is
I appear for state respondents.
you are also appearing for the eastern
Yes, my lord.
they are a party East Kolkata Wetland
Yes.
you are different yes
Yes. My lord, page 130 is the order under challenge. My lord, may I place it for your lordship consideration? Peruse the report of the Chief Technical Officer, East Kolkata Wetlands Management Authority, dated June 23rd, 2025, prepared pursuant to the last order dated May 16, 2025. It appears therefrom that spot inspection was conducted and that unauthorized constructions were detected. In view of the situation, the EKWMA authority is directed to take steps for removal of the unauthorized constructions in accordance with law and to bring back the wetland to its original state. Release the matter on July 22nd, 2025. Steps taken to remove the unauthorized construction shall be placed before this court on the returnable date. So, my lord, these directions were issued on the basis of, my lord, a report prepared by the wetland authorities, my lord, which was submitted before the court on 23rd of June 2025, and the order was also passed on 23rd of June 2025. My lord, the first point I am seeking to, my lord, canvass before your lordship, if your lordships may kindly take the trouble to compare, my lord, these directions with, my lord.
was the 16th May order first
My lord, 16th May order, my lord, has not been annexed here, my lord. But I can hand over, my lord, copies of it. Lord, I tender my sincerest apology. I have only one copy of the order.
you were not given a copy of the same
My lord, I was handed over a copy of the report, my lord, on 23rd of June 2025, my lord, the day on which it was submitted before the court.
but you were present on that date
Yes, on the previous date. Your lordship is looking at, my lord, the previous order, my lord.
16th May
Yes.
was passed in your presence na
Yes.
why didn't you pray for an report copy
My lord, the report, my lord, was, my lord, prepared subsequent thereto, my lord, and
see paragraph 2 of the order read that order
of my lord, I do not have an
16th May, you don't have it?
no. my
Oh,
lord.
take, oh,
এটি হচ্ছে সেই report। এই যে
Shall be placed before the court on the adjourned date. My lord, shall be
oh, shall be placed.
placed.
Acha, acha. So it was handed over to you on 23rd itself.
Yes.
Now tell us what is the wrong in the order.
Yes. My lord, first of all, lordships, my lord, kindly compare it with page 36, my lord, which is
Is
my lord.
page 130 with page 36.
Yes, which is my lord, the prayer portion of the writ petition.
prayer A has been granted.
Prayer A and prayer B, both, my lord. So, my lord, at the interlocutory stage, my lord,
And you take exception to this report.
No.
my lord, I was not given any
But
opportunity.
23rd June report you were given.
Yes, on that date itself, my lord, the order was passed.
We had one interruption on 23rd. They did
I
not
was
appear.
no.
They did
I-
not appear, and
বলি
no
একটু
one
আমি
sought for
বলি।
any
My
accommodation.
lord, I had to leave early, my lord. My mother had an appointment with a doctor. Accommodation was sought for on my behalf. That has not either been recorded or, my lord, not granted. My lord, I am not on that, my lord.
Now where is this report of the, you have annexed here?
Yes, my lord, report, my lord, starts from page 88, my lord. 89, actually. Page 90, my lord, last paragraph. My lord, the factum of inspection and the findings, my lord, have been recorded.
Seventh of April 20. Prior to this May, there was another order.
Another
of
inspection.
7th April 2025 order was there.
7th April, my lord, order was passed by the Honorable Single Judge, my lord.
Why haven't you brought those orders on record? Not annex it.
My lord, all the orders, my lord, I have not annexed. My lord, initially
You have
there was
neither you have annexed 7th April nor you have annexed 16th May. 7th April
my lord,
order
I
is
have
there.
a copy, my lord.
Tell us, read it.
My lord, paragraph 3, my lord, the allegation of the petitioners were
That was
recorded.
in your
my-
presence. That was
Yes,
in your.
yes. The allegations were, my lord, recorded, my lord. Thereafter, my lord, the respondent number 6 along with the respondent number 8 and 9 are directed to conduct a joint spot inspection and file a report before this court on the adjourned date. Thereafter, my lord, the list the matter once again.
Yes, place which portion you are wanting to place, page 90.
Yes, my lord, page 90, last paragraph, my lord, records the findings, my lord, arrived at during.
Yes, please.
Yes. Respondent number 8, subdivisional officer Baroipur did not attend the joint field inspection nor he sent any representative of it. However, the joint field inspection was conducted by the representatives of respondent number 6, Chief Technical Officer EKWMA and representatives of respondent number 9, Bellaro Sonarpur along with officials of PS Narendrapur. During the field inspection, it was noticed that on a part of RS Dag number 9 Mouja Jagodipota such and such, a plot of land was found surrounded by a boundary wall with an iron gate at the entrance of the said plot. A community hall was noticed adjacent to the boundary wall of the said plot. A temple and a small pond were noticed on the same plot. In front of the temple, a brick and concrete made plinth of an unauthorized construction was found. Now, lordships may kindly compare it with, my lord, page 122, my lord, the report of the spot inspection.
Yes, what?
Now, under the heading land classification, your lordship will find that under the 2006, my lord, Wetlands Act, this particular plot of land has been classified as urban rural settlement area full.
So you are occupying which RS Dag?
My lord, this 9.
So
Dag number
in 9 you are raising construction.
My lord, this, my lord, on the first occasion itself, I wanted to, my lord, point it out to the honorable single judge, my lord, that the writ petitioners have approached the court, my lord, by suppressing material facts, my lord, and with unclean hands. My lord, it is the writ petitioners, my lord, who had sold these plots of land to us. My lord, I have annexed, my lord, the deeds, my lord, which were executed, my lord, in our favor. Now, my lord, thereafter, my lord, first, my lord, they became owner of a large plot of land, my lord. Thereafter, my lord, they divided it into smaller plots. They, my lord, prepared a master plan, floated a scheme, alluring, my lord, intending, my lord, purchasers, my lord, to settle there. With, my lord, common facilities like, my lord, a park, a pond,
This
temple.
they had done prior to selling the land.
Yes. Thereafter, the lands were, my lord, sold to us. My lord, we contacted them. My lord, it started from 1991. My lord, since 1991 till 2024, almost 150 plots have been, my lord, sold by them. And they, my lord, has also filed a civil suit, my lord, which has completely been suppressed, my lord. My lord, they, my lord, could not obtain an ad interim order of injunction, which was refused by the learned civil judge, my lord. These facts have also not been, my lord.
No, they preferred the suit against whom?
Against us. The appellants before your lordship.
Why?
My lord, alleging that we are trespassers and we are, my lord, trying to forcefully, my lord, take possession of the land and raise construction. My lord, I have annexed the plaint and the order passed.
Where is that?
Yes. My lord, the plaint, my lord, your lordship will find, my lord, page 216, it starts.
216.
16, my lord. Lordship may kindly comes to 217, my lord.
Prayer is at 221.
Yes, yes. My lord, Shotraj Singh.
What are your names?
Yes, my lord, Shotraj Singh and Manoj Keswari, my lord, they are, my lord, the writ petitioners. Shashank Shaw, Ramasroy Shaw, Ramswaresh Shaw, Alok Singh, Manoj Singh. These are the 5 appellants before your lordship.
Show us the schedule.
Yes. My lord, there is page 221, my lord. The prayer as well as the schedule.
Now, where are you residing?
My lord, some of us, my lord, are residing there, my lord. Some of us, my lord, has alternative accommodation, my lord. But frequently, my lord, visits. Now, my lord, 225.
So what are the numbers of your plots?
Yes, yes.
There will be subplots now in RS Dag number 9. You said that
RS
they
Dag
have
number
divided-
9 and 9/69, my lord. My lord, it comprises of, my lord, a large plot of land,
No, no.
10.34 acres.
We are concerned with RS Dag number 9.
9.
Because the writ petitioners wanted your removal from RS Dag number 9.
My lord, it's a large plot of land, my lord.
969.
9 and, my lord, 9/69. Batadag. My lord, 225 is the refusal of the ad interim prayer of injunction. My lord, the paragraph which starts with the word reading the plaint. and thereafter the ordering. So, my lord, in my humble submission, this is also a classic example of forum shopping, as well as, my lord, suppression of material facts approaching
How
this honor.
do you substantiate your case? Forget
Yes.
about them.
Yes. Now, my lord,
So
I was.
you are according to the
I-
trespassers, and according to you are deciding at RS Dagna.
I have, my lord, I have annexed, my lord, the deeds also, my lord. If your lordship so desires, my lord, only one of the, my lord, instrument, my lord.
Mr. Sen, what demolition you will undertake?
No, I think I have no instruction whether it has been undertaken or not. So
It
far
has
the
been, it has
so
been.
far the order is concerned, the interim order or the direction passed by the single judge.
Huh.
I have no instruction that to what extent, my lord, they have taken steps for compliance of the same. But my lord, only thing is this, that since there was an order for joint inspection that has been done, and there is no dispute that it comes under that, my lord, the Wetland Act and that Wetland, that rules 2017, Preservation and Management Rules 2017. Now, my lord, it is also, my lord, the under the rules of 2017 that even non-wetlands but comes under that category, then, my lord, there should not be any permanent construction, or nature of use cannot be changed as per the rules. Now, as per the inspection report, it appears yes, construction is there. But yes, that is true. But I also admit that there is no whisper that it does not appear when the construction has been made, or whether it before the act came out, because they said that since 1991, they have purchased the plots and subplots and all these things done by the writ petitioners himself or themselves, according to, and should file. All these things were suppressed before the court, or those facts were not brought. I cannot say suppressed. Those facts were not brought to the court. Only simple fact that this is a part of wetland and construction has been made or is going, construction is going on. Then the police complaint, and then matter came up by way of writ court, and simple prayer that construction be removed because of the wetland under the Wetland Rules and Act. And the order passed a joint survey except BLRO, joint survey done, and that has been placed before the court, and the court passed that order. Now I leave it to your lordship that, my lord, that after this, my lord, the honor.
You are also in problem. Then whom?
That is true.
Whom we will review?
2021, my lord, the construction has started.
My lord,
You have
Page
suppressed.
26.
You should have disclosed the suit before the learned single judge.
Yes.
And you have made an assertion that you are in possession. There are deeds to show that you sold the property.
No, they are, my lord.
Did you bring the plaint on record before the learned single judge? No.
No.
Did you bring the refusal of ad interim order before the learned single judge? No. Did you bring the deeds of sale before the learned single judge? No.
Now, my lord,
What is this?
So why we will entertain your writ petition itself?
but suppose, my lord, whatever instruction I have, my client has disclosed these things after the repetition being filed. Now, my lord, the first thing, my lord, kindly suppose that this particular plot of land
First, you answered the suppression, sir.
not disclosed, my lord, not disclosed to me. Subsequently, in course of hearing, I came to know.
You would appear for these sort of people. They have
But
not,
I admit,
they have not disclosed to you.
Should
They
have.
have suppressed before
Should have
you.
no doubt about it.
And it's a very vital.
Yes.
It's a
Now
very
that-
vital, because matter not only relates to that the construction on wetland, matter relates to who is in possession, who is the owner, and who are going to be dispossessed from that.
Absolutely correct.
Now, my lord, may I submit? My lord, yes, I have understood what has fallen from your lordship.
Because one thing is very clear, that this is not a public interest litigation. In the guise of this is not a public interest litigation.
Any construction is going on, Mr. Sen.
But the report,
Completed,
the report, it does not appear from the
Does not
report that
say.
construction going on. The report said it appears that a temple, a hall, and boundary wall, it is standing there on, or it is there. The report never said that its construction is going on. No.
But it's impossible
Completed.
to ascertain from when these three have.
Very difficult.
2021, Millard, the construction has started. I have stated at page 26, paragraph 6. Petitioner number 1 used to reside at Lock.
How do you know 2021?
The petitioner, what has informed to me, Millard.
You said your clients are saying they were in America till 2021. They came and suddenly found this construction.
Yes, because
Then
they
the
reside
construction was there, could not have been in
They reside
2021.
elsewhere. Petitioner number 1 resides at Lucknow. Petitioner number 2 resides at USA.
Very good. Now, these deeds which you have annexed here, have you gone through this? Have you asked your
I have taken
clients?
instruction that this particular plot of land, 9 and 9/69, Batadak, these particular plots of land were never transferred to them. There are small plots of land. Now, Millard, this particular land has not sold to them. Millard, for the time being,
Then that should be the subject matter of that suit court.
It is.
Now, Millard, may I? Now, Millard, for the time being, your lordship kindly suppose that it is true that I have sold the land to them and they are in possession and they are the owners of this land. Now, Millard, my respectful submission before your lordship is that, Millard, construction on wetland is not at all permissible.
As Mr. Sen rightly pointed out, this is not a public interest litigation. What is your locus to challenge that?
Millard, I am the owner of this.
So therefore,
Then no public interest litigation by an interested person.
Otherwise, I could have filed public interest litigation, Millard.
So if you're the owner, then your
Millard, kindly
statements
take
are.
section 9 of this act first.
Still remain to be the owner. If you have sold the land, what remains
Land
with
was never sold to them, Millard. In my respectful submission, this
Why should
particular-
we believe you when you have suppressed facts before the writ court? Why should we believe you? Tell us. We understand your contention that whether where the land is situated, whether it comes or not, etc., etc. These points you will argue. Your prayer is that you remove all demolition. Now this
Here my
picture,
prayer
as
is
it turns out, was that you were the original purchasers. Now you have allegedly sold it to some person. Now they are wanting to raise construction. You are now coming and saying that no, I am the owner. How can you trespass and make construction on my land? That is your pleading in
Millard, for
the
the time being, your lordship kindly suppose that they are the owners. Now, Millard, still they are not entitled to raise any construction.
What is your locus to say that if we assume that they are the owners?
Millard, anybody can challenge. Anybody. irrespective of the fact.
And you file the suit, that is exactly what you've prayed. Decree for declaration of plaintiff's title over the suit property.
Yes, because without due process of law, I cannot evict him.
Right, so you should have disclosed this before the learned single judge.
Yes, obviously, my lord. Now, my lord, kindly comes to page, my lord, section 9 of the act.
Yes, next.
Yes. Let-
Oh,
We are returning it.
My item number
yes.
my lord, item number 30,
35, my lord.
34, 35, Mr. Joydeep Gupta is appearing on behalf of the appellant in item number 34. My lord, he is appearing on the virtual mode, my lord.
My lord, can your lordship hear me?
My lord, I am appearing for respondent number 1 and 2, both in 34 and 35.
Lord, because of the uncertainty in the city today, my lord, I was advised not to arrive. Lord, if your lordship can, my lord, accommodate us on some other date, my lord, or if your lordship wishes to hear us on the video, my lord, we can go ahead.
This is 34 and 35
35, my lord.
together.
Yes, yes.
My lord, I am
There are two
appearing for
different
this.
appeals. There are two different appeals. One is by Reserve Bank of India. The other is by Axis Bank.
Mr. Gupta, you are appearing for whom?
Reserve Bank.
Reserve Bank of India, item 34. There are two different appeals from the same order.
Bank.
Mr. Jayanto Mitra.
Mr. Jointo Mitra is appearing on behalf of Axis Bank. My lord, he has sought for an accommodation today.
So, figure after 2 weeks.
My lord, may I make one submission on behalf of the respondents in both the appeals?
Yes.
Respondent number 1 on behalf of in both the appeals. My lord, we have received an email yesterday stating that there are some discrepancies, some documents are not available in the paper book which we have already filed and circulated. Now, my lord, subject to your lordship's convenience, my lord, if we find that some other documents are left out, my lord, subject to your lordship's leave, my lord, may we file a supplementary paper book in course of day after tomorrow, and your lordship will kindly fix the matter any day convenient to your lordship in the next week.
Mr. Ghosh, let us go through the paper book. If so required, we will consider.
My lord, kindly fix it at any day. Convenient.
My lord, may I request the week of 17th, my lord, if your lordship doesn't mind?
Pardon?
May I request the week of 17th? My lord, may I request, my lord, a date? Your lordship is, my lord, fixing a date in the next week, my lord, or 2 weeks later.
Then 20th August, it will be there in the supplementary list. 20th August.
Yes, yes.
My lord, I am
20th
told that
August,
21st August will be, my lord, difficult for both Mr. P.K. Dotto appearing and Mr. Jayanto Mitra also. My lord, 20th, my lord, we have no problem. Let it be fixed on 20th. Let it be fixed on.
Yes, yes, my lord.
Very well.
Yes, 20th.
Lordship. Deeply obliged.
Deeply obliged, my lord.
Yes. Yes, Dato.
36, I am opposing the application.
Whom you are opposing, Mr.
The
problem.
contempt matter.
Yes, that's the contempt matter. I should keep it with tomorrow.
Let it be in the list. Yes, 37.
7, my lord, I appear for the appellant. My lord, we'd mentioned this matter because of there was some urgency in the matter, my lord. There's an application for stay which is pending, and they're proceeding with the contempt. The writ petitioners did not appear last occasion also. There was a resolution that day as well.
Come tomorrow. কত থেকে জানবো?
15, তারপর 17 তারপর 25 না 23 কি এটা ছিল
লিখে
আজকে মার্ক করে রাখতে হবে।
On release item number 14.
দেখে যাও।
17, my lord, I beg to appear for the appellant, my lord. The paper books, my lord, were directed to be filed, my lord, if that be taken on record, my lord, the paper book.
You file it in the department.
My lord, informal paper books as was directed, my lord. I sought because the department said is filed before the court, my lord.
Acha, keep it with you when we next day take it up, we will keep
But
it.
only if this can be, because this voluminous kindly considers
So
this.
you are handing the burden to us. Handle the burden for 5 more days. Yes, next.
19, Your Lordship, I am being led
Milord,
by.
I appear for the appellant in this matter, Milord. Milord, there are two appeals, one in the original side and one in the appellate side, which is before your lordships, from the common judgment of the learned single judge. Milord, the issue involved is the question as to whether a scheme of merger sanctioned under the Companies Act is liable to stamp duty in West Bengal, where the properties forming the subject matter of the merger are situated outside West Bengal. Now, there is an order that both the appeals in the original side and the appellate side will be heard together. Milord, therefore, Milord, the original side matter also has to appear. And secondly, Milord, in the original side appeal, after a long lapse of time, the state has now filed an appeal against the same judgment with an application for condonation of delay. That has to be considered also. So I was humbly submitting, Millard, let this matter appear along with the original side matter sometime next week, Millard, so that, Millard, your lordship can pass an order on both the matters, and including the application for condonation of delay, which has now been filed.
Shall pass that order when if you next take it up, you remind us about the original.
So you are fixing it, Your Lordship.
It has to be in a separate list, no? Yes, not today.
Lordship, it's the appeal of the state, if it can be taken up. It's an excise matter. We are the successful writ petitioner, whereby the state authority has been ready to refund us the entire money on change of management.
Let us see, come tomorrow. Yes, next.
22, 24.
No, 20.
No, 23 টা ডাকো। কবে আপডেট? না না, এটা যেটা মেনশন করেছিল ওই মামলাটা? হ্যাঁ, এইটাই
বললো না যে আপনারা ডাকেননি, কল করেননি। কোনটা অম্লান মনে আছে?
Five. 29, 30, 31.
একটু ডেকে দাও তো।
My lord, I am troubling your lordship, my lord. Item number 7, my lord. Your lordship had adjourned the matter till 4th August, but that is the monthly list, my lord. And as per earlier direction, my lord, your lordship had
We've kept it on the 6th.
6th, my lord. I am grateful.
আমরা আসছি। Original side একটা আছে।
7th August.
7th August.
My lord, grateful.
আসছি, 5 মিনিট পরে আসছি।
বুঝলেন তো?
With leave, but I'm mentioning to put in leave to file without certificate copy.
Why? When was the order?
11 July 2025.
He's here.
Is that?
Yes, sir.
Well, this is, I'm assailing an order passed on 15th of July by the learned single judge, where the learned single judge, dismissed my writ petition on the ground that it involved.
Quite close to the High Court.
Yes, Your Lordship. As not very close.
Very close.
And to a certain extent, I also feel that I can join him.
Yes, we should.
There is also Mr. Malad,
Later.
Mr. Shuddhastha Banerjee also appearing, Malad. He is also trying to enter in the virtually, Malad.
Who?
Mr. Shuddhastha Banerjee, Malad. He is also there in the matter, Malad. But he is also trying to enter, Malad.
No, enter.
Trying to enter.
Trying to
You're not stopping him.
No, practically, Malad, there is some link problem like that. He is there in the link, Malad.
But that we are not to be.
No. That is my mistake, Malad. I am really extremely sorry.
Yes.
So, the order passed is that the writ petition is not allowed or dismissed on the grounds primarily that it's a show cause notice which has been challenged and it arises out of disputes from a contract. Now, may I just give a very brief overview of the matter? The petitioner, before Your Lordship, had entered into an agreement after a successful tender, with the respondent number 1 for putting up cameras for the election period, election.
Yes.
Chief election officer had issued this tender, and there were certain terms and conditions. According to me, had fulfilled all the terms and conditions. During this interregnum, when the project was being undertaken, there were letters from their side, our side, discussing and trying to crease out whatever had happened. If there was any problem, that was taken care of, whatever it is, Now, the point is, after we had given our final invoice, payments have also been made finally. Now, the precondition for payment was that they would receive completion certificates from the various districts where I have put up these cameras. And these completion certificates were placed with the chief election officer, and payments were released. Furthermore, while the payments were released, the respondents took necessary actions under the tender to make deductions of certain follies which I had committed under the tender. Like there were a few cameras which had gone into offline mode. Some cameras were not working. For that, the tender itself provided how much of deductions could be made. Now, the final payment was made. After that, this tender required me to put in 2 performance guarantees and my earnest money deposit. According to the tender terms, earnest money deposit was to be returned immediately on the award being granted of the tender. That was not given back. And the performance bank guarantees had a claim period till 31st of August 2025. Validity was of 2024. So 1 year of
claim period for them. Now, my lord, I write to them from April saying that, look, I have completed my work. You have given me all the payments. After that, there is no use holding on to my performance bank guarantee and the payment of refund of my earnest money deposit. So give it back to me. My lord, till May, I have been writing to them. Suddenly in July, my lord, I receive a letter.
No, but
Sorry.
after the work was done, you were paid the entire amount.
Yes.
So that bank guarantee is pertaining to which liability of
Well, that is what I am also worried about, because they have already deducted.
No, you have said that so far as the other flaws which were concerned,
They have deducted.
that they have already deducted.
I can show from the payment particulars given by them.
So now after that they issued a show cause notice to you.
Now they have issued a show cause notice, putting up referring to certain letters.
When were you paid? You give us some dates.
27 December 2024. 27 December.
22nd December 2024 was the payment made.
Yes, my lord.
167.
Page 167, if your lordship wants to keep the page number also, my lord.
Page 167. Very
My
good.
lord.
This payment was made after deduction from you.
Yes, well, my lord, kindly comes to that page once, my lord. I'll just try and establish that, my lord.
Page
167, my lord. Right. My lord, kindly sees this is dated 30th December 2024. I'm sorry, I got the date. But kindly, may I read it, my lord? Sanction is hereby accorded to an expenditure amounting to rupees 29 crores odd, my lord, towards payment of marginally noted bills submitted by the petitioner for webcasting solutions for live monitoring of the poll-related activities in connection with general election to Lok Sabha in the state of West Bengal. And the work order is mentioned. Deduction of claim has been made as per clause number 3.21 of the NIT. Casting solutions dated 17 January 2024. And my lord, kindly notices the fourth column. It says deduction on the claimed amount as per the recommendation of IT steering committee and scrutiny by webcasting cell of this office. Now, my lord, if your lordship kindly has a look at the clause which they are referring to at
now a total sum of 2 crores, 49 lakhs, etc. was
not
deducted.
2 crores, my lord, I think a bit more than that. 23 crores, 24 crores, 96, 19, 444. So I had billed 29 crores, they've given me 24 crores. And my lord, they made a deduction in terms of 3.21 to the extent of nearly 94 lakhs.
So after deducting, you were paid how much?
Well, this amount.
23 approximately.
Yes, my lord.
Then what happened?
Then, my lord, I issued several letters, my lord, from January to May. From 16 January 2025, then 28th April 2025, last of them on 31st May 2025. That's it. But I have a. Now, my lord, after 31st of May, on 7th of July 2025, my lord, a letter is written, which is the letter under challenge. That is at page 176. My lord, by these letters, my lord, your lordship can go through that, but I'll just assist your lordship. I said, give me back the performance bank guarantees and the EMD for this year. And my lord, they are also holding my EMD since 2019. That Lok Sabha election also, my lord, I had not been returned the EMD. So these were the letters, these 4 letters. Now, my lord, suddenly on 7 July 2025, my lord, kindly takes page 176, my lord. This is after, my lord, December I have received. Seeking clarification relating to webcasting in Parliament general election, that's the subject, and release of EMD and bank guarantee. I am directed to say that they have been assigned the work of live streaming webcasting, and they refer to that work order. You were requested. I am further directed to remind you that by letter dated 6th May 2024, clarification was sought regarding the details of camera along with the time framing during which they have become offline during first and second phase. Copy enclosed. You were requested for clarification regarding cameras, which went offline in the third phase on by letter of 10th May 2024. You were requested to provide complete recording of webcasting footage of certain polling stations where elections were held on 25th May 24. No recording was made. And then 5. Then despite the issue of advisory from this end, we were compelled to send you an email of 1st June 2024 seeking clarification as to why more than 1,300 booths went offline at 8:30. So many booths were showing offline. In none of the above cases, you supplied the list of cameras along with the time frame during which they went offline and provided the complete footage as was repeatedly requested. Contention the camera had gone off because of the network services inability to make the network available could not be substantiated. Rather, pending software upgrade was a major reason for this fault. Then, they refer to another email of 1st June. This is my reply that substances like Vaseline, Fevikwik, or toothpaste had been applied on the cameras. And you were facing difficulty, especially in falter from elements that might uninstall or damage the cameras. Actually, your representative technicians never visited the polling booths to ensure the continuity of webcasting, which is a crucial component of ECI mandate non-force multipliers for maintaining vigil over the polling exercise. Your suggestion, nothing but an afterthought exercise since you made no efforts to contact the such and such. Well, kindly, may I pause here for a moment, Malad? This is of June 2024. My replies are also of June 2024. After they make payment, nearly after near Malad, they are suddenly raising these issues.
So why did the single judge did not give you protection?
Malad, the single judge went.
What was the reason?
I'll point out, Malad. But may I just place this one, because I'm nearly to the end.
Yes, yes.
Because Malad, I have a very important submission to make on this part, Malad. Then, Malad, 10, 11, and 12, you were requested providing the cameras to be used for validation by TEC, Eastern Region DOT, but you willfully disobeyed. Cameras used were only supporting IoT SIM, which created lots of problems. Very few of representatives were present for monitoring in the control room. But these are vague, no particulars, vague. Which cameras? Because I have replied to the earlier notices. Last, kindly sees, just after paragraph 16, Malad.
No, why do you say no particulars given?
Malad, the earlier letters which they have referred to, Malad, I have replied to all of them. After that, they make further statements here, saying that cameras used were only supporting IoT SIM, which created lots of problems during recharge exhaust period.
This is a new point you are saying?
Malad, this is a point, yes, Malad.
Yes.
Representatives, we have already dealt with that earlier, Malad. Malad, kindly comes the last part of this, Malad, the penultimate paragraph. In the above context, I am further directed to request you to show sufficient reason why the EMD and bank guarantee should not be forfeited, and appropriate penalties including blacklisting.
Please read clause 13.
In all the 7 results found out, average 4,500 to 5,000 cameras were switched off for continuous time frame of 2 to 4:30 hours, spanning over different time ranges of the day. Second phase of the poll showed 2 hours of continuous interruption. Malad, not a single district named. And Malad, most important thing, Malad, their person has given me the completion certificates.
Where is that?
Malad, all these are there, Malad.
So if 5,000 cameras were switched off,
I don't know what did I supply, Malad, and what was happening. And Malad, if I may say this, I don't think whether they are tarnishing me, rather they are tarnishing themselves, I believe. The elections become tarnished. Page 119 to 143 are the completion certificates. Issued by the district election officers. On the basis of these, Malad, payments were made.
So the learned single judge directed them to consider.
Malad, that is what I am on, Malad. Directing them to consider, Malad, kindly appreciates, I'll rely on one judgment, Malad. Blacklisting cannot be done like this, my lord.
No, they are not on blacklisting. They're only asking you to show cause.
My lord, that is what I'm saying. A show cause for blacklisting also cannot be done. Where, my lord, I say, my lord, this is arbitrary and unfair. But on the facts of the case, your lordships kindly appreciate, the payments were made. Payments were made in accordance with their payment mode. My lord, may I just take your lordships to two clauses of the...
So, Mr. Roy, you are submitting that you are not in a position to give further reply.
No, my lord.
That no reply is required.
No reply was given.
No, to this show cause.
My lord, that show cause refers to letters and my replies.
No, Mr. Ray, while we were asking you those questions, you said certain new points have been added.
My lord, may I just say this, my lord? New points, because I say this is a bold statement. It's a bold statement. That's why it's a bold statement made.
No.
Other than these, my lord.
So, if it's a new point, then you obviously haven't got the opportunity to deal with those points.
My lord, again, I say, my lord, kindly appreciate the case which I'm trying to run here, my lord. My lord, I am on the unfairness of this show cause notice. Why do I say this, my lord? First of all, it's a threat of blacklisting, which has been deprecated by the Supreme Court, saying that you just cannot say that I will consider you penalties for blacklisting. You cannot do that. Just because I've asked for my EMD and my performance guarantees back, my lord, that cannot be done. And my lord, I also say this, that the kindly looks into the show cause notice. Maximum, it only deals with breach of contract. In breaches of contract, my lord, show causes for blacklisting are not allowed.
But there has been no finding of guilt against you.
My lord, that is the threat.
No, you give your reply.
My lord, that is the threat, my lord.
Sir, they have put you some questions which according to you have already stand answered in my previous.
So therefore, my lord, it's no use going.
Say that in reply.
Then what will be my requirement of going there? Because I know there's a predetermined mind now.
How can we shut them down at this stage, Mr. Roy? They are.
But I am saying.
You have got the end money.
Sorry, my lord.
They have deducted whatever deductions required. They have paid you the money.
If your lordship is considering that, my lord, that makes this notice further arbitrary. Because, my lord, kindly sees the clause. My lord, kindly appreciates, kindly sees the events one after another.
Your bank guarantees are valid till the
31st August 2025. My lord, I am on this point, my lord.
They cannot invoke till 31st August.
They can. They have not invoked. That is my. Oh, I'm sorry.
No excitement.
No, my lord, my lord, they can. That is my submission. That they have not invoked my bank guarantee. They don't do anything. But issue this notice out of nowhere, and it's a complete threat, my lord. Blacklisting is a threat. My lord, today if I'm blacklisted, all my work will come to a standstill. I wouldn't be able to participate in tender. That is the arbitrariness. Where does it come from, this question of blacklisting? Well,
yes,
the judgment which has been passed, with humility, I say, my lord, it was primarily on the point that contractual matters cannot be looked into in a rich jurisdiction. Well, that with humility, I say, my lord, that is really not the bar which your lordships have put on yourselves. It is said that contractual disputes can be looked into, even if it's factual. If I can show that it's an arbitrary action. Well, what is arbitrary and what is unfair?
No, Mr. Ray, I don't think you need to labor on that because the learned judge has not held that it's not a complete bar.
No, but my lord, the learned judge says that, my lord, since there are factual findings which are required to be looked into, therefore, such contractual matter, my lord, she was not minded to assume jurisdiction. My lord, paragraph 19 of the order, if your lordship kindly sees, my lord. Sorry. The petitioner asserts that the action of the authority is arbitrary. Therefore, the submission of the petitioner cannot be accepted by the court. Prima facie does not appear that the authority acted arbitrarily. Whether the authority could have acted in the manner in which it has acted is required to be adjudicated by the competent forum, which is certainly not the writ court. But I am complete. Malad, I'll just show parts of the order and then I'll try and refer to certain judgments which I think, Malad, will be assisting my cause, Malad, if you lordship allows me. Malad kindly sees in paragraph 21 of the judgment, Malad, United Limited, the court rate.
Today, what interim order do you want?
But I'm wanting a stay of this notice, Malad.
All right.
Because today is the last day, Malad, as extended by the single judge, Malad. The single judge has extended the time period.
So why, Mr. Roy, if suppose today if the show cause reply is sought from him, you are given, it comes with a fresh order on the basis of which the forfeiture as you are pleading. That is a penal order which is being passed at the interim stage. You cannot read. So we will ask them to pass that order within a specified time. And we will hear Mr. Mukherjee about that. And then consider, because you are now what is pinching you is the
blacklisting.
No, not blacklisting.
Yes,
They
one of
will-
the threat of blacklisting.
They will have to pass a final order on the
Malad,
basis
maybe,
of.
Malad, but what I submit, Malad,
So
kindly.
we will keep those points open. What is your problem? You come back to us. If
So
the
your
show cause
lordship is keeping the writ.
subject to what Mr. Mukherjee says. No, we will dispose it off. We will dispose it off. We will say that your show cause will be given, reply will be given within such and such. They will take a final decision and we will give you protection till such time for a further period of 1 week. If it goes against you, come back.
Malad,
And
then may I just make a challenge to the blacklisting part and seek your lordship to quash it at this stage?
At this stage,
Yes,
Mr.
Malad. I will try and assist your lordship if I can, Malad. I'll only show one judgment, Malad, and that is it, I believe.
Blacklisting decision has not been taken, Mr.
Malad,
Roy.
the
There is a
itself,
threat.
the show cause itself, that can be, Malad, done, Malad, by your lordship's honor. Malad, may I just try, Malad? Malad, may I just place this judgment, Malad, kindly? Malad, I'm sorry, Malad will kindly be noticing your lordship is stapled, Malad. I'm so sorry. Malad, this was, sorry. just place a few paragraphs of this judgment, my lord. I know, my lord. My lord,
No, just we are interacting.
no. My lord,
Not that we have made up our mind or said it.
my lord, I got this judgment. Obviously, I grew wiser, my lord. So, my lord, I thought that I would show it to your lordships if your lordships are convinced, my lord. My lord, paragraph 27, your lordships will kindly take. My lord, this is a tendered matter, my lord, where there was an agreement. And my lord,
My lord, may we have a reference, my lord, of the.
yes, I'm sorry. It's 2025.
Which paragraph, Mr. Ray?
Sorry, it is paragraph 27 onwards.
Now you have to get your priorities right.
I'm sorry. The quote in the Blue Dreams Advertising Private Limited and another versus KMC reported in 2024 INSC 589 while quashing and citing the blacklisting order as affirmed by the High Court in almost identical facts observed as under. In case there exists a genuine dispute between the parties based on the terms of the contract, blacklisting as a penalty cannot be imposed. The penalty of blacklisting may only be imposed when it's necessary to safeguard the public interest from irresponsible or dishonest contractors. And the corporation being a statutory body having a higher threshold to satisfy before passing such blacklisting, and therefore the measures undertaken by it should be reasonable. Again, the aforesaid decision of this court was rendered in a case where the blacklisting order was already passed. May I, my lord? I have my responsibilities, my lord. However, what is important for us to say is that when there are guiding principles explaining by this court as to when and in what circumstances a blacklisting order can be passed, then in our opinion, such principles should also be borne in mind by the authority at the time of issuing a show cause notice. We say so because in the facts of a given case like the one in hand, on the face of which it could be said that there was no good reason for the authority to issue a show cause notice calling out on the contractor why he should not be blacklisted. Why ask the contractor to face the proceeding with applying the aforesaid principles? The issue of show cause notice would be an empty formality. We are saying all this keeping in mind the facts, particular facts of this case. Therefore, the authority is expected to be very careful before issuing a show cause notice. It is expected to understand the facts well and try to ascertain what sort of violation is said to have been committed by the contractor. As noted above, there is always an inherent power in the authority to blacklist a contractor. But possessing such inherent power and exercising such power are two different situations and connotations. There may be a power, but there should be reasonable ground to exercise such power. To put it by way of illustration, the police has the power to arrest, but it is not necessary that in all cases arrest must be effected. The police should know whether at all arrest is necessary. We may put it a slightly different way. Take, for instance, the show cause notice in the present case is the final order of blacklisting. The final order in any case cannot travel beyond the show cause notice. Therefore, we take the show cause notice as the final order, whether it makes out a case of blacklisting. This should be the test to determine whether it is a genuine case to blacklist a contractor or visit him with any other penalty like forfeiture, AMD, recovery, or damages. We say so because once an order of blacklisting is passed, that same would put an end to the business of the person concerned. It's a drastic step. Once the final order blacklisting the contract is passed, then the contract is left with no other option. Go to the High Court invoking the jurisdiction under Article 226 of the Constitution, challenge the same. If he succeeds before the single judge, that's well and good. Otherwise, he may have to prefer a writ appeal or LP as the case may be. This again would lead to unnecessary litigation in the High Court. The endeavor should be to curtail the litigation and not to overburden the High Courts with litigation of the present type, more particularly when the law by and large is very well settled and there's no further scope of any debate. As observed by this court in Eurasian equipment, an order of blacklisting casts a slur on the party being blacklisted and is stigmatic. Given the nature of such an order and import thereof, it would be unreasonable and arbitrary to visit every contractor who is in breach of his contractual obligation with such consequences. There have to be a strong, independent, and overwhelming materials to resort to this power, given the drastic consequence that an order of blacklisting has on a contractor. The power to blacklist cannot be resorted to when the grounds for the same are only breach or violation of a term or condition of a particular contract, and when legal redress is available to both the parties. Else, for every breach or violation, though there are legal modes of redress and which compensate the party, like the corporation before us, it would resort to blacklisting and at times by abandoning or scuttling the pending legal proceedings. Plainly, if a contractor is to be visited with the punitive measure of blacklisting on account of an allegation that he has committed a breach of a contract, the nature of his conduct must be so deviant or aberrant so as to warrant such a punitive measure. Sorry. A mere allegation of breach of contractual obligations without anything more per se does not invite any such person to punitive action. Usually, while partisan tender, this is not too much essential, Malad. And finally, Malad, at the very end, Malad, at para 37, Malad, the blacklisting part was quashed and set aside by the Supreme Court. Malad, Malad, may I just read part of Malad, also the last part of para 36, Malad. The show cause, in other words, Malad, just 5 lines from the bottom. In other words, the show cause notice in most of the cases is issued with a predetermined mind.
That's the part I was.
I'm sorry, Malad. It has, Malad, Mr. Shastri pointed it out to me, Malad. I'm sorry.
That's the part.
It has got to be issued because this court has said that without giving an opportunity of hearing, there cannot be any order of blacklisting. To meet with this, just a formality is completed by the authority of issuing such a show cause notice. Now, Malad, in this backdrop, Malad, kindly considers the facts. Kindly considers the facts. I have shown your lordship payments made after deduction. Malad, the agreement and the tender conditions also provides for deductions. That clause I was about to show your lordships, Malad, and they have adhered to that. Now, Malad, they have not invoked my bank guarantee also.
So you're saying once the payment is made, it's an admission of satisfaction of the work done by you, and hence no punitive action can be taken.
No.
This is the
my submission. And with regard to the returns of the MD, Malad, that is also the case. But at this point, I'm more threatened with
so much worried about the EMD and bank guarantee, but more really much more with the blacklisting part.
Malad, if I go and participate there, and if I take the point of return of the EMD, Malad, the penalty will be the blacklisting. They have got no reason, Malad. Kindly, if your lordships kindly permit me to show 2 clauses of the tender, Malad. That's why I'm submitting, Malad. Mode of payment, 70%.
Otherwise, it's not always there. It's not.
Malad, yes, but we'll kindly have a look at page 71. (3.21). Payment will be made as mentioned in the terms of the agreement, will be paid on receipt of the bill on the basis of the satisfactory completion of the work within the given time frame duly certified by the district election officer. All these I have annexed to my writ petition and the paid payments on the basis of these. Then, Malad, kindly sees. No advancement will be made for payment at any stage to be made, but it's not essential. Kindly comes the next page. The following also have to be complied. The selected bidder should provide 100% server network and power uptime as standard, applicable during the election day as declared by the client, and shall be applicable for 24 hours as decided by the client. The bidder should ensure. Now, see, Malad, service availability has been, Malad, defined into 8 standards. And for that, the corresponding deductions have been mentioned. And deductions has already been made from their document. It is not my document, Malad. Their document. And then kindly see, Malad, 3.22. The selected agency will be required to submit security deposit, 10% of the accepted bid value in the form of bank guarantees in favor of chief elector before the firm work order is issued to it. In case of failure to execute the work as per terms and conditions, security will be forfeited. We will also forward in case the selected agency fails to enter into agreement or refuses to work even after work is offered on the basis of technical and financial evaluation. So, once they give a completion certificate, they make payment after deductions. This is done in December 2024. And from January, I start asking them that give me back, give me back. They say they don't reply. And then 7th of July, suddenly this comes up. And after yes, as extended by the learned syndicates. 21st minute.
Anything else you want to show?
May I just for the completeness, that contractual disputes can be looked into by your lordships, If your lordships wants me, I can show that. I'll show only one judgment,
This judgment goes against you. Ordinarily, the read court should not entertain any petition.
Sorry,
Ordinarily, the read court should not entertain any read petition pursuant.
That has been my first submission. There is not an ordinary case. We fall under the arbitrary and unfair.
Have you come across anybody ever saying that my case is ordinary?
I don't know, that's what we come here
just
for.
asking you.
We come here for that only,
We all think that the case we are
that
doing
is
is
why-
extraordinary.
But why I'm saying it's
Clear
not
facts.
ordinary? Why I'm saying it's not ordinary? On the I'm drawing some kind of inspiration from this judgment, as to what is ordinary and what is not ordinary.
Okay, is that
This has gone up our courts, Yes. This has been a major discussion on the jurisdiction of your lordships in judicial review under 226 contractual matters. This is a 4 judges bench, kindly sees, your lordship will kindly follow from paragraph 55.
Section 70.
55 onwards, the Supreme Court makes divisions of exercise of jurisdiction at different stages of a contract. And more or less holds that it can be exercised at every stage. But I'll only take your lordship to para 57. Needless to say that in matters concerning specific modalities of the contract, such as required work, execution methods, material quality, time frames, supervision standards, and other aspects imparting the tender's purpose, the court should usually refrain from the interference. But I say, I have come before your lordship not because of this. What I am saying is, is that para 59. Therefore, what can be, sorry, next page, Therefore, what can be culled out? Or may I just take your lordship one paragraph above from 58? Judicial review is permissible on the same page, to prevent arbitrariness of public authorities and to ensure that they do not exceed or abuse their power in contractual transactions and require overseeing the administrative power of public authorities to award or cancel contracts or any of its stipulations. Therefore, what can be culled out from the above is that although disputes arising purely out of contract are not amenable to writ jurisdiction, yet keeping in mind the obligation of the state to act fairly and not arbitrarily or capriciously is now well settled that when contractual powers is being used for public purpose, it is certainly amenable to judicial review. But here also, my lord, the termination was challenged on the ground of arbitrariness. But today, kindly consider the man. I'm beseeching your lordships, my lord. Kindly see the line, the dates, and your lordships will find, my lord, from 30th of December 2024, after making payment till 7th of July, they don't make any complaints. They have already deducted whatever they could deduct. And if I'm asking for it, my lord, that is to the maximum my contractual rights of getting it back. Why blacklisting? Any of their allegations which already has been, my lord,
The answer to your why blacklisting
I'm sorry,
lies,
I should ask.
no, lies in clause 3.22, which says that blacklisting could be a consequence.
My lord, clause 3.21.
Huh?
My lord, refers to 3.2.
3.2.
3.21.
Yes. Yes. Number of payment will be made on product. Work has to be executed to the satisfaction of the authority. No, there was a.
They have given that.
23 action certificate.
Blacklisting.
The satisfaction, my lord, of the authority. It is talking about the forfeiture of security.
No, there was the term blacklisting used.
Blacklisting
In one of the,
quite a few times, my lord.
Huh?
I'm sorry, my lord.
No, maybe, but I thought that I found that word somewhere.
I stand corrected, my lord, because I have been continuously searching. It should.
Sure. First time it
This is the first time they mentioned. They want to forfeit. They want to show us.
Yes, you have no problem with the forfeiture and EMD as of now.
As of now, man. Why blacklisting? But obviously, the next step will be, my lord, I'll give my, this is practical. I'll give my show cause reply. The next thing will be either blacklisting, which I believe would be, or else, my lord, if your lordships give me some protection for blacklisting, next step will be invocation of the bank guarantee. And then I'll have to run. My lord, that is what, my lord, Justice Pardiwala has said. And the problem is, and if I'm blacklisted, my lord, then I'm.
How long will you take? We have a matter fixed at 2 p.m. We have to hear Mr. Mukherjee.
But I've placed the judgment formally, my lord.
My lord, may I make a suggestion?
Yes.
My lord, kindly keep it tomorrow, my lord. We'll not take any steps in the meantime. I'll address your lordships tomorrow.
Mr. Mukherjee is saying I don't.
Court trusted মহিলা
যখন বলবে আমার তো বললে বলবে যখন বলবেন
Mr. Mukherjee, how long will you take? Just give us an approximation.
My lord, my learned friend cited, my lord, 2 cases, and I believe a third is on its way. My lord, so my lord, I'll naturally, my lord, take some time, my lord, to deal with this.
Are you citing a third?
I will not.
No, he's restricted to 2.
Yes, because I showed Unitech. I believe Mr. Mukherjee is saying that I will show Unitech. It's on the same point. So I do not want to multiply, my lord, since your lordships have lot of time. my lord.
Mr. Mukherjee, can we keep it on 7th of August? Whether
Yes, yes. Yes, yes, with that assurance. Not a problem.
then Mukherjee says we are not recording it.
And I have completely have complete confidence.
Heard Mr. Royal Learned Advocate appearing for the appellant. Due to paucity of time, Mr. Mukherjee Learned Senior Counsel appearing for the respondent could not complete his arguments in view thereof. Senior counsel, in view thereof, list the matter for further consideration on 7th as fixed at 2 p.m.
But with your lordship's leave, but I completely respect what fell from Mr. Mukherjee. But may I just also write a letter to the respondents saying that the matter is before your lordship, and it's my request from my side. It will be a request not to take any steps. Because I understand Mr. Mukherjee is there, but I also
My lord,
have government authorities, my lord, I have very bad experience. So that is why I'm a bit. Mr. Mukherjee, I'm sorry, it has nothing to do with you, my lord, Mr. Mukherjee.
No, no, that's okay.
If I can just.
My lord, I can only say my learned friend had need have no apprehension, my lord. That will be.
Today, I think.
I will just issue
Mr.
a letter.
Mukherjee is here.
Yes, yes. Well, that's why I said I will only issue. I'm not asking for any orders from your lordship.
Why do you need to issue?
Well, the problem is, my lord, if something of this sort happens, my lord, then
Mr. Mukherjee
my lord, I'll leave it on. I'm sure Mr. Mukherjee will. No problem, my lord. I'll.
We are not recording anything, Mr. Mukherjee.
Yes, yes. Not a problem.
I'm in good hands, my lord. Both that way and this way. I'm grateful, my lord.
They have not come.
They have concluded their submission.
So, Mr. Sharda, just one clarification we wanted. So far as the this Sujata matter is concerned, in that the vacancy declaration was that 1st of September 22 memo. Now this 1st of September 22 memo is also a part of the earlier matter. In the earlier matter, your contention was this 2013 control order after coming into effect of the target public distribution system, this 2000 it has become redundant, and the as regards the proviso, your contention was that it has been fully implemented. Now what we are I was trying to ascertain, now today suppose in the original side matter we hold in your favor and we hold against you in the other matter, then the benefit which will fall for
Then
you,
in that case, I will not be benefited. Ultimately, my writ petition pending, because this order will cover that order also.
now today if we conclude the hearing, because you have almost completed on that. Now I was talking with my brother also that suppose today we decide in your favor and we decide against you in the other matter, then your benefit out of the second matter will fizzle out. But your matter is so many appeals and so complication, and you rightly submitted that will not be a hearing fixed within 2 or 3 days. Within 2 days, I will complete. I cannot.
Today, I shall conclude my submission. So far, the submission of Mr. Shishyanna Bandyopadhyay and Sushobhan Sengupta is concerned. And so far, the private response.
Mr. Sharda, who are for the other appellants?
Mr. Bandyopadhyay are good.
No.
They have all entrusted the job to me. They all.
All right. So you.
The first day, Lordship may remember Mr. Ramagodal and others all interested. So I am appearing representing all the appeals. There will be no further submission. And I can conclude, my lord, if on the next day, half an hour, I shall conclude my submission, if so far the Mr. Bandyopadhyay is concerned. Judgment, both the matters, same day.
কত সুন্দর বলে দিচ্ছ। We want to conclude both the matter hearing and then at least dispose of both the matter by whatever.
That's also my, that's.
But there are so the bulk of papers, it is very, unless you assist us, it is becoming very difficult for us. You have argued this Shishyanna Bandyopadhyay argued say about 2 weeks ago, 3 weeks ago. Now after you give the reply, we can get the recapitulation. His argument was that even if I don't prefer appeal for order 41, I shall have
within
a right.
5 to 10 minutes, just brief facts I can place before your lordship, possibly the entire thing will be clear within 5 to 6 minutes, because issue is very short. If your lordship allow, because coordinate bench has already confined the matter to a particular point. There are 3 issues before the learned single judge, 2 issues in my favor, 1 issue is against me. And the coordinate bench, division bench, also confined to only that point.
But ultimately held against you, that is still surviving.
On that point. On that point.
2013 is still surviving.
Yes. On the basis of a notes of submission that it is not yet fully implemented. But before the Supreme Court, submission is that yes, it has fully been implemented. And from the
Supreme Court, they went against which order?
My lord, There is a previous proceedings. Duration scheme was under challenge.
That is under which NFS?
Duration scheme was under challenge. It is a state scheme. In that writ petition, along with other points, one of the point was redundant. 2013 court order became redundant. During the course of hearing, we argued our case, but the then Advocate General submitted before the division bench, presided over by Justice Das, as his lordship then was, that we have not fully implemented. Relying on that submission, the division bench came to a conclusion that since the Advocate General is submitted before the division bench, they have not fully implemented. We are not considering that point.
Which division bench?
Justice Das, as his lordship then
Acha,
was.
acha. So then
duration scheme has been declared ultra virus, but that point has not been considered.
What has been declared?
Duration scheme, which was under challenge in those writ petitions, that has been quashed and set aside.
Now this duration scheme came under the NFS Act.
That was our case. That was our case. That was our case.
Then what is that? You have annexed a copy of an order of Justice Hiranmoy Bhattacharya. That was pertaining to which? That is National Consumers Cooperative Society or something. In your first writ petition, it is an annex.
Why I have shown it? Initially, I have 72 or 91 dealers. 91 dealers. In the year 2023, 40 dealers have been delinked. So far that matter is concerned. National consumer or
But
something.
that deletion was on the basis.
We have not challenged. We have not challenged. That deletion in terms
But
of
then that deletion is also contrary to your argument which you are advancing.
No, because that was declared, no vacancy has been declared prior to 2013, old vacancy. There was some case pending. Ultimately, they own and dealers have been delinked. Now it becomes 41 to me. Then fresh vacancy has been declared, which I have challenged again.
1st September 20.
If your lordship allow me 5 to 6 minutes time, brief facts I can place before your lordship. Just
Which one you are saying then?
Shetara Begum, appellate side, first item.
Acha, Shetara Begum, where is that order of the division interim one? Which appellate side we filed it.
Well, these are the order.
ওদের তো
এটা দিন।
এই
এটা দিন, order দুটো দিন।
order
24, passed by the coordinate bench, presided over by Justice Bakshi. Mr. Swanso for the appellants contends that the state has taken prevaricating stance with regard to full implementation of the National Food Security Act.
আমার যেটা চেম্বার থেকে appellate side এ But whatever you are submitting, you will have to again repeat on the next, because they will have to take a point that it was made in our absence, so I do.
Possibly not, my lord, because in their presence date has been fixed and they have not objected to fixing the date.
They don't object, there is no problem. But again, then we have to ask you the answer.
And they can take it from the system also. They can take it from the system also. May I read my lord the order?
Just yes.
Mr. Swanso for the appellants contends the state has taken prevaricating stance with regard to full implementation of the National Food Security Act 2013, hereafter referred to as the 2013. In the state, before the Honorable Supreme Court, the state had pleaded that the act has been fully implemented. However, in the written submission placed before the Honorable Single Bench, the state was that act has not been fully implemented. Honorable Single Bench ought not to have relied on such submission, which runs contrary to the stance taken by the state in the special leave petition pending before the Honorable Apex Court. Mr. Suman Sengupta with Mr. Shishana Bandhopadhyay, learned junior stance counsel, contend that the consensus stance of the state is that the act has not been fully implemented. However, states are afforded to implement the act fully in respect of their submission. They are to the observation to the impugning judgment that the Advocate General in a collateral proceeding had informed the court that act has not been fully implemented. Appellants are fair price shop owners and MR distributors under the West Bengal Public Distribution System Maintenance and Control Act 2013. Their principal grievance is that the issuance of vacancy notice under the Statute Controller 2013 for appointment of new dealer under the said order. It is contended
Please
that the
read para 3 once again. Appellants
are fair price shop owners and MR distributors under the West Bengal Public Distribution System Maintenance and Control Act 2013. Their principal grievance is the issuance of vacancy notice under the West Bengal Control Order for appointment of new dealer and also would be allowed distributor under the said order. The challenge is the vacancy notice. It is contended that the State Controller 2013 is no longer in force as it stands superseded by National Food Security Act 2013.
But
And
Mr. Sharda, this NFSA, where does it say control order superseded?
no, I'm just first control order framed by the central government for public
2001.
2001. Following 2001 and Section 3 of the Essential Commodities Act, as a delegate, they framed two control orders 2013, one for urban area, another for rural areas. One is 8th of August 2013, another is 12th August 2013. Prior to that, there was no control order. Now, National Food Security Act came into force in the month of July after 2013 control order framed. National Food Security Act, a new concept has been taken that the targeted public distribution system. Previously, it was not a public distribution system. The definition of consumers, entire thing has been changed. Your Lordship may remember there was APL ration card, above poverty line, BPL, all goes. Now the ration cards have been identified, eligible household. This BPL, APL, all goes. So entire new system. After coming into force, National Food Security Act, central government framed targeted public distribution system control order 2015. In 2015 control order, there is a clause that 2001 central control order supersedes. And there is a proviso also, if any state not fully implemented, National Food Security Act, in that case, previous control order will continue. That's the issue before your Lordship. Our case is that From their document, I shall show to your lordship, 2016 September, they have fully implemented. Their case is that Section 12 of the National Food Security Act gives some power, reforms. These reforms will continue. For betterment of public distribution system, Section 12 says ration will be delivered to the consumers through EPOS machine. There will be a weighing machine, thumb impression. These are all reforms. So far the implementation is concerned, from their document in the supplementary affidavit I have annexed that this has been implemented 2016. And before the Supreme Court, they have also filed SLP in ground number R, page 44, that the submission which has been recorded by the Honorable Division Bench, presided over by Justice Das, is wrong. We have fully implemented National Food Security Act.
But Mr. Sharda, this is a disputed issue which has arisen. According to you, they have said fully implemented.
Not I am saying, my lord, just a minute. They are saying.
They are saying. No,
They are saying.
Your stand is also that it has been fully implemented.
They are saying also. Why I am saying so?
It is on the basis of the submission made by the Advocate General.
No. My submission is that.
Your submission is fully implemented.
And their documents also says. Yes.
That is
Yes.
to be
Yes.
adjudicated.
Yes.
Your stand it is fully implemented. In support of such stand, you are saying that there is no controversy as regards,
Absolutely.
because the Advocate General himself has said.
No, the Advocate General says not implemented. Before the Supreme Court, they says implemented.
Very good. So there is a dispute. Now Justice Portonayok held on the issue. It was the opinion of the single judge that no, it has not been implemented.
Why? Because in the notes of submission, Shishano Bandhopadhyay submitted, which has not been handed over to us either. It is the recording of the learned single judge. Since the state advocate filed a notes of argument saying that it has not been fully implemented, I am accepting this position.
Where is that portion?
Can you take up my stay application? Kindly come to my lord, page 329 is the judgment.
Yes, yes.
Kindly turn to page 343. This is the only issue. This is the only consideration. Page 343. 343. Paragraph 17. At the outset, the veracity and effect of ground taken in the SLP pending before the Honorable Supreme Court, being ground number R at page 54, cannot be decided. Can you take note of? In the present writ petition, however, it is pertinent to note that the Mr. Shishano Bandhopadhyay, learned Junior Standing Counsel for State of West Bengal, in his written notes of arguments, has categorically stated that certain provisions of National Food Security Act 2013 has not been fully implemented in the state of West Bengal, such being the position as per provisions of clause 1 sub clause 2 of targeted public distribution system. Controller 2015, the Central Controller 2001 will continue to apply. Therefore, in the state of West Bengal, the Central Controller 2001 has its application since the NFSA 2003 has not been fully implemented in the state of West Bengal and cannot be said to have been superseded by so. This is the only findings against me, entire judgment. Since there is a notice of submission, I am accepting the sense. Whether it is Supreme Court's further other submission, document says I am not accepting anything. This is the only issue, only point. Learned single judge, other 2 points in my favor. So far this point is concerned, this notice of submission has not been handed over to us. Admittedly, we have also not been.
How shall we interpret this physical issue which has arisen? Suppose you are saying.
I am not saying. I am placing the document. I am placing the document.
Clarify the position upon the principal section last one. Disclosing whether has been implemented fully without tracking the connecting.
Can it be done, my lord? on the basis of the notes of submission, when there is a specific document.
That is why the coordinate bench called for a.
Absolutely. And in the affidavit, they have only stated everything has been implemented. Everything. Only reforms what? What is the meaning of reforms? It will never be completed. From their document, I shall show to your lordship, director, principal secretary says it has been implemented from 2016 with a particular date. My case is that reforms will continue. Unless implemented, there is no question of reforms. Section 12, they have relied on in their affidavit. I shall show to your lordship. Kindly take up their opposition. First opposition, affirmed on report. Sorry, my lord, report. No, opposition. Sorry, my lord, opposition. Affirmed on
13th August 2020.
13th August. Your lordship, kindly take up the table next page. Para 3. The first sentence start paragraph 3. My lord, my lord.
No, before you come to that, another thing, please give an answer. Kindly come to page 165.
165. My lord, I'm in 165.
Kindly see the now therefore, second paragraph.
Now therefore, in
That
excess of the power
for the single judge was that these are fountainhead is section 3 of the ECR.
Section 3 and section 5.
Entire power flows from section 3. And according to them, these delegated legislation, control orders and everything, these are independent by themselves. Which
That has
was
been
negated by the learned single.
in my favor.
Which was held in your favor. Now, apropos that, I am asking you that this control order says that it is in exercise of section 3 of the.
Read, continue, read.
And read with 2030.
Read with 2001.
Sorry, read with 2000.
Central control order. Because section 5 delegates the power to the state by the central government. Section 5 says that section 3 does not give the power to the central state governments. Section 5 says that central government shall issue an order.
No, state government shall issue.
Central government shall issue an order fixing the terms and conditions, empowering the state to frame control order.
Where is that?
Where
That is
Kindly take my lord's essential comments there. That's the issue, my lord. Unless there is a central control order, only section 3 cannot give the power. Kindly take up.
Section 5.
বই আছে ওই থাক ওই বাড়িতে ওই ঘরে আছে 24 থেকে নিয়ে 24 first section 3 then section 5 by notifying an order.
We will go to please
Fine,
answer
fine.
our queries. Kindly come to
এটা কোড করা আছে না কোথাও কোড করা আছে
annexure.
Case 3. 2000.
Section 3 and 5 has been quoted at page, my lord. 339 of the judgment. 339 of the stay application.
এই টার্গেটেড কন্ট্রোল এই এক্সেপশনটা দিল দুটো ক্লজ একটা এক্সেপ্ট যেটা ভাবছে এবার এবার page 245 licensing statement shall issue an order section but not inconsistent with the section 3 এর stated কোনো government shall issue. Yes, what you are showing?
Section 3 and Section 5.
Yes, section 3.
Section 3 is the power of the central government to frame rule under essential
So
government.
where is that portion?
Section 5.
Section 3 has nothing to do with state government.
Section 3 empowers the central government to
Central government.
only central government. NT 33.
Yes.
Now Section 5. Well, it has been quoted in page 339 also.
Section 5.
Delegation of power. Have you got pen?
Yes.
The central government may, by notified order, direct that the power to make orders or issue notification under Section 3 shall, in relation to such matters and subject to such conditions, if any, as may be specified in the direction, be exercised also by such officer or authority subordinate to the central government, or such state government or such officer or such authority subordinate to the state government, or may be specified in this direction. So Section 5 directly does not give any power. Section 5 says central government shall frame a rule specifying the terms and condition, in manner state government shall frame the rule, exercising power under Section 3, read with the particular control order. Following the same, state government frame rules in 2013. In exercise of the power under Section 3, read with Central Control Order 2001. First control order framed by the state government 2003. In exercise of the power under Section 3, read with Central Control Order 2001. 2013, same. Even 2024, new control order came into picture. In exercise of the power under Section 3, read with 2015 control order. Well,
That we are not got, sir. That read with 2015 control order we are
No,
not.
they are saying there is no need to take assistance of the central control order. Only Section 3 is empowers. This is from the board. My submission is it is from the board. State is not saying so. State saying that I am enjoying the power under Section 3, read with central control order. In 2003, in 2013, even.
But it is their argument that these are independent.
But this is not their conduct. Conduct says they are relying on. They are relying. Then why they are relying on in all control orders? Even in 2024.
No, the 2015 control order kindly come targeted.
My lord.
Page 227.
My lord.
Now, page 227, they are giving
power to the state government.
Clause 9 of the annexure.
Yes.
Clause 9 of the annexure. State government shall issue order.
Yes.
Please read.
Page
245.
240. Just a minute. My lord.
Licensing and regulation of fair.
Under her so the state government shall issue an order.
Under section.
Yes, that's our case.
Your argument was that Section 3 does not enable this.
Kindly read my lord next line. Read next line. The state government shall issue an order under Section 3 of the Act, but not inconsistent with the order for regulating the sale.
So very good. Your argument was Section 3 state has no power. Then why this language has been given?
Section 3 empowers central government to
issue orders.
Under Section 3, every person can frame control orders.
Where is that?
Section, you'll also kindly see this.
Your argument was state has nothing to do in Section.
That power has been provided under Section 5.
Yes.
But you have to frame the rule under Section 3.
State
Controlling. Section 5 is the delegation power, not power to frame rule. Section 5 delegates the power to frame rule under Section 3. Kindly read well at Section 3. To control, monitor essential commodities, Section 3 is the only section. But it does not give power to the state government, only it confined to the central government. Now, Section 5 gives the power to the state government to frame rule in exercise of the power under Section 3. Because Section 3, kindly read well at Section 3.
Then state can exercise, in exercise of Section 3, state can issue a control order in terms of section 5.
Read with control order to be framed by the central government.
Your argument, if we have understood.
Just section 3 empowers the central government
Hmm.
to monitor, control public distributions by essential commodities. Your Lordship, kindly take note of, otherwise, kindly see what is the power. Section 3. Power to control production, supply, distribution, etc. of essential commodities. If the central government is of the opinion that it's necessary to expedient to do so for maintaining or increasing supplies of any essential commodity, or for securing their equitable distribution and available at fair price, or for securing any essential commodity for the defense of India and the effects of so, it may by order provide for regulating, prohibiting the production, supply and distribution thereof, and trade and commerce thereon. Then kindly read, my lord. A, B. Kindly turn to page, my lord. Subsection 2. A, regulating the license, permits or otherwise. B, for bringing under cultivation, for controlling. D, for regulating by license, permits or otherwise the storage, transport, distribution, disposal, acquisition, use or consumption of essential commodity. E, for prohibiting the withholding from so and so. F, for requiring any person holding in stock or enough so and so. But this power has been given under section 3 to the central government. Only to the central government. Central government may
Issue orders.
to issue orders. Now kindly come to section 5. Now your lordship will understand. Section 5.
Yes.
Delegation of power. The central government may by notified order. So section 5 directly does not give state governments the power. Central government under section 5 shall issue a notified order fixing the terms and conditions, which manner they will frame the rule. The central government may by notified order direct that the power to make orders or issue notification under section 3 shall in relation to such matters and subject to such conditions, if any, as may be specified in the direction, be exercisable also by the such officer or authority, such state government or such officer.
So your argument is the first line by notified order.
My lord, my
That
lord.
is the 2000.
Unless there is a notified order,
First notified order was 2001.
my lord,
Central government.
my lord.
Now in exercise of section 3 read with 2001 control order, state framed the
First 2003, then 2030.
2030. So your argument is the power to delegation, on the basis of delegation of power, state is exercising control.
Being a delegate. Being a delegate. So unless there is a central control order, even section 5 does not give the power straightaway. Central government, section 5 says you may frame rule under section 3, but that rule should be consistent with the central order, notified order. That notified order was initially issued in 2001, now 2015. And they have issued 2024 control order also in exercise of the power under section 3 read with 2015 control order. Whatever they are submitting from the board. Their conduct says without assistance from the central control order, only section 3 does not give any power to the state to frame any rule. Because there is a term, kindly see, my lord, not inconsistent. You have to frame rule in terms of the central control order.
Where not in
Section 5, the central government may by notified order direct that the power to make orders or issue notification so and so shall in relation to such matters and subject to such conditions, if any, as may be specified in the direction. Direction means the order. It should be consistent with the order to be issued by the central government under section 5 delegating the state to power.
Then what was the state's argument? Why did they say?
State says, state, I am not on bar. State says it is required. 2001, 2003, 2013, 2024 also. In all control orders have been framed in exercise under section 3, read with 2015 or read with 2001. Now they are saying this is wrong. We should not have. But after filing the writ petition, after filing the stay application, new control order came into force, 2024. Even 2024 has been framed in exercise of the power under section 3 read with control order 2015, central control order. Then how can they say there is no need to take assistance of the central control order? Only section 3 is enough. 24 the control order.
আপনার ওখানে রেখেছি কালকে হ্যাঁ 3 কপি আছে কালকে রেখেছি
hand over 2024 control order. Just first paragraph, kindly read.
হ্যাঁ 3 আছে আচ্ছা
Kindly read 2024. In the court, they are saying, kindly see the date, 1st August 2024. Whereas the Central Government of India, so after followers of section 3, Essential Companies Act 1955, has issued targeted public distribution so and so 2015. And whereas in pursuance of the clause so and so of the target public distribution section, control order so and so 1915. Now, therefore, the governor is exercising the power conferred by section 3 and section 5 of the Essential Commodities Act 1955. Read with Government of India, Ministry of Consumers Affairs, so and so control order 2015.
Why do they add section 5?
Delegation.
65 kindly come back.
No, I have seen the delegation section 5
Section 5
has not been mentioned. Because not mentioned. But control order has been mentioned in all control orders. Central control order has all been mentioned from 2003, 2013, even 2024. And learned single judge has held in my favor also.
So their argument is that this is a control order issued directly under section 3.
If that is so, my lord.
No, that is their argument. No? It is directly under section 3. It is independent. Independent of the control order.
Yes.
Now, please come to the argument they advanced.
This is their argument. This is their argument. Absolutely, this is their argument.
You are
and they have
part. We are learning. We have to understand. No? Achha, please come to the judgment.
My lord, may I submit one thing? This point has been held in my favor. State has not preferred any appeal.
Which one?
So far, this independency of the section 3 is concerned.
Yes, that is Shishano Bandopadaya's argument is irrespective of appeal. But
that I shall distinguish, but possibly not. Yes.
Mr. Sardai,
Yes. You'll also consider it. Yes.
Mr. Bandopadaya's argument is that I have filed a cross objection.
No. That has not been admitted. Beyond time. No section 5. I shall show.
Cross objection is
not within time.
Is a point of law involved. We will have to condone the we have to condone the section 5.
I am not saying so. No section 5 has been filed. No copy has been served upon us. But that has never been admitted. 30 days time, your lordship knows, from the date of in the eye of law, there is no such cross, either of the parties.
So you will answer to us as regards the power under order 4120.
Yes, that I have brought. Now
please come to the judgment.
Judgment impugned. It starts from page 329.
329. Kindly come to paragraph 4, 330. Let us understand what he is submitting.
Paragraph 4.
Page 330.
Yes. On the contrary.
Yes.
Mr. Shishano Bandopadaye, learned junior standing counsel, appearing for the state respondents in WPA number so and so, submitted that section 3(1) of the Act of 1955 is the fundamental foundation of all the powers of framing guidelines in connection with the maintenance and regulation of essential commodities or for securing the distribution and is available at section 5 of the Act, deals with the delegation of powers in favor of the state government or such officer or authority subordinate to the state government. Section 3 read with section 5 of the Act 1955 empowers government of India to delegate the power to the state government by way of issuing notification. Kindly take note of by way of issuing notification. They are admitting this is their submission. Page 335, second line. Empowers government of India to delegate the power to the state government by way of issuing notification to issue orders, including control orders in relation to such matter and subject to the condition if any specified in the said notification. But anything remains. This is a submission recorded by the learned single judge. That not only section 3, the central government shall notify an order fixing the terms and condition, and state has to follow the same. This is their submission recording. The government of India.
By way of issuing notification, where you are reading?
Page 7, page 335. Top.
Empowers government of India to delegate the power to the state government by way of issuing notification.
Yes.
That is what you are
Yes. This is the submission.
To issue orders, including control orders in relation and subject to the conditions.
So it should not be inconsistent with. This is our case. Now the entire scenario has been changed after coming into force National Food Security Act. 2015 deals with the 2013 National Food Security Act. Consumer has been changed. Quantity has been changed. Everything changed. How can you issue a vacancy notice under 2013 to deal with National Food Security Act? Now the consumer has been defined, my lord. Eligible household. No APL, no BPL.
Come to the bottom.
My lord.
At the middle of the page.
My lord.
Thus, all the control orders.
Thus, all the control orders, be it central control order 2001, PPTS control order issued by the government of India or state control order also issued by the government of West Bengal, are independent delegated legislature.
This is wrong, according to you.
Absolutely. Their first part of submission is that unless central government notified and control order, there is no scope by any of the state to frame any rule. And further submission, it should be consistent with that central control order. And that gives the power to licensing authority. Section 3 never gives any power. So far the public distribution system is concerned. They have also placed before Lordship GSR 800, 1976. It's deal with, my lord, only foodstuff, not public distribution system. And there is a concurrence is required to be taken from the central government, GSR 800. But 2015 control order, 2001 control order never says you have to take concurrence. That deals with foodstuffs, not public distribution system. Learned single judge rightly held.
It's self-contradictory.
Please read independent delivery made by two separate government and these control orders derive authority from section 3 of the
Act of 92, which is the foundation of all of them.
Clause 9 of TPDS. Control order also provides state government shall issue an order under section 3. Now he is.
What section?
This is clause 9.
Yes, my lord, what section 9? How to issue license. First consider, section 9 says how you will issue the license. Kindly come to section 9.
Clause 9 says the state government shall issue an order under section 3.
Yes.
Of the act, but not inconsistent.
My lord, not inconsistent with the terms and condition of that particular control order. That's section 5.
What I'm trying to know is why there is mention of section 3.
Because section 3, the only power gives to the central government or subsequently state government to control, monitor National Essential Commodities Act, essential commodities goods. Section 3 is the only source of power for monitoring, controlling essential commodities. Rice, paddy, these are all essential commodities. Section 5 never gives any power. Section 5 delegates the power to the state.
Further, clause 9 of TPDS provides state government shall issue an order under section 3. Moreover, NFSA 2030 itself refers to PDS control order of 2001 in section 24(5)(c). Please explain this.
My lord.
This clause. They are saying NFSA itself confers power to PDS control order 2001 in section that 2001 control order is no longer your contention.
Supersedes.
It has gone. Now, then why there is a mention of that order in section 24(5)(c) of the NFS Act? Let us come
Yes,
to that.
I'm showing you.
Page
Yes,
270.
Section 20.
NFS Act, section 24. Obligation of state.
Yes. Because at that material point of time, 2015 control order was not in picture.
Very good.
National Food Security Act came into force July 2013.
September.
What will be the vacuum? In material
Came into in September.
2015.
No, 2013.
2000 National Food Security Act. But for monitoring, controlling, targeted public distribution system, no control order was there.
Yes.
This control order came into force only in the year 2015. During this gap, what will be happened? They have to follow my lord.
It is only for that gap period it was given.
217.
Page 217.
24(5)(c), bottom.
We have extended the interim order till when?
30th July.
13?
July, 30th July, last week.
30.
End of July. May I read, my lord? Our time.
Determination has changed.
Assignment.
Not for that. Our entire table gets disturbed.
New judge will elevated tomorrow.
No. She wanted expired to here.
But your lordship's determination possibly has not been changed. Changed. Residuary.
Group
Relieved.
2. Now we have group 2.
Education.
Are you happy or are you sad for us?
I have no
You
case. I
found the two of
have no case in group 2. Huge pressure. Every matter appeal. Every day
We
notice.
were surprised to note in group 9, ও না 30 না 30 তারিখ তো প্রাইমারিটা 28 তারিখ সোমবার।
But point is not so big. Just this is the point which we have discussed today about iron or good. This is the only point. Because they have their conduct accepted that unless there is a central control order, they cannot frame any rule. And that rule should be consistent with the central control order. This is their conduct from the bar, so many submissions.
Then you show us, you deal with their statement as regards NFS implementation and you conclude.
Absolutely.
Deal with the judgment of Mr. Bandyopadhyay.
Yes, yes. Both the Bandyopadhyayas.
Yes.
I shall deal with. On the next day, NFSA documents showing 2016 they have implemented, and their only case is that reforms. I shall argue 10 to 5 minutes, then my lord only judgment distinguished. Because this is the point.
And in the other case, your stand is that that interim order was not coextensive with the applicant order.
I have shown the division bench judgment which says locus.
No, this is the first issue. The second issue which Mr. Bandyopadhyay had stressed on was not being a party to that proceeding, and that order being an order in personam, he is not bound by it. So
But what is the order? Not to grant license.
Just
Yes.
make your submissions on this.
Not to grant license. Because his case was not approved at that material point of time. There are 10 applicants. The question of making every 10 applicants does not arise. And order is very simple. Proceed, but not to grant license to anybody. Because his case has been approved.
Order on the authority.
Yes.
Authority is a party in both.
Yes. And in their opposition, state also says the interim order till exits, till disposal of the petition. Only question fallen from your lordship that why I have filed an application. But they have also filed an application for addition of party after dismissal of my appeal. Even the question is that, my lord, even I taken a wrong recourse, does an illegal order be validated? If the order illegality is there, that should be cost answer. Either of the party taken any plea wrongly, that does not stand on the way, because they have filed their application of addition of party after 6 months from the dismissal of that appeal, knowing fully well that unless this interim order is vacated, there is no scope. Then all on a sudden, original side, writ petition. 150 matters have been moved. This is the change. Decision কাকে দিল? Decision কাকে দিল? নতুন জজ
পাঠিয়ে দিও তো কত অবধি দিল?